We should start.
Yes, I'm okay.
So I'm gonna start.
Okay.
So good afternoon. We're gonna start. Good afternoon, everyone. Welcome so much. For those of you that don't know me, my name is Rosa Celorio. I'm actually the Associate Dean for International and Comparative Legal Studies at GW Law School. And I just wanted to say that this lecture is part of our Visiting Scholar Speaker Series, which is really designed to showcase the wonderful research being conducted by our visiting scholars at GW Law School. We're very lucky. We have visiting scholars that join us from everywhere around the world. We have Allison Anthony here, who's also a visiting scholar and presented a few weeks ago. We also have Aisha Shmood, who's also a visiting scholar. We'll present on Monday, November 14th. And we actually have a very special visiting scholar presenting today, Professor Cássio Cassagrande. And I just wanted to say that he's a professor of constitutional law at the Universidade Federal Fluminense in Rio de Janeiro, in Brazil. And he's also a visiting scholar with us. And his lecture will be the influence of FDR's New Deal policies in the making of Brazilian labor legislation. And I just wanted to say a few things about Cássio before he actually gives his lecture. I have to say, working with Cássio has been an absolute pleasure for us during his visiting scholar stay. He's dedicated, he's fully engaged in his research, but also when I think of Cássio, I think of what a wonderful citizen of this law school he has been. He's been so engaged, always intellectually curious. He's made so many friends. Everybody loves Cássio. You know, when Cássio shows up, it's like a light enters the room. You know, there's always a lot of good energy that enters the room. And I have to say, you know, when I think of Cássio, you know, I like having models for our students, you know, how they should be as professionals in the future, you know, and I think you're one of those models.
Oh, thank you very much.
You know, I would love for most of our students to be like you know.
Thank you.
If we had that, I think the world would definitely be a much better place, you know.
Very honored to hear this.
Yes, so thank you again for doing this,
Okay.
Cássio, and I'm just gonna give you the floor, and afterwards we'll take some questions at the end, and please also help yourselves to lunch. And I also wanted to thank Leah Calabro for making this event possible, and also all the support that Selena Davis always gives to these events. And I also want to introduce Jinxie Dai, who's also gonna be supporting the International Comparative Law Program. So thank you all.
Thank you, Rosa, for your kind words. Welcome, everybody. I'm very happy to be here this morning. Very happy to see our students here in this session. I would like, first of all, to thank Rosa again, not only for her words, but for being so welcoming, so generous, and so friendly all this time. I would like to thank Professor Leah Calabro, who made everything possible to have this session. And I need also to make some thanks to Professor Robert Cottrell, who I have attending his classes. He really told me he would like to be here, but he's in Brazil this week for a conference. So I will speak for Brazil, say, oh, I will be in Brazil, I can't be there, but he has been very important with suggestions for my research, and it's a really amazing experience to know and to work with him. I would also to thank Professor Carl Clare from the Northeastern University in Boston, who has helped me a lot with his research, and also Professor Gus Cochrane from the Agnes Scott College in Decatur, Georgia, who's a friend of mine, very interested in Brazil, and has made a lot of contributions to me. I would like also to thank my dear friend Alison, who arrived together with me here in GW as a visiting scholar the same day, so she has been very supportive, very encouraging. Also Aisha, my colleague, that I knew recently, but we have become friends too. And Selena, I could not forget you, that has, since the selection period, always very helpful and very kind too. Thank you, Selena. Well, this is ongoing research. I mean, as it is about comparative law, I'm studying here in the United States, the part of the United States law, and I will follow this research in Brazil, studying Brazil. But obviously, I will talk about Brazil for you, although it's not already complete. Before I get to the point, I would like to tell you where I come from, about my university. You know, this is the Brazil's map, and you can see that there are subdivisions, are the states. Brazil is a federation like the United States, and you have here the Rio de Janeiro state and the Rio de Janeiro city. Like you have New York State, New York City. Rio de Janeiro is the capital of Rio de Janeiro state, but our university is not in Rio, but in a city across the bay, that is Niterói. Universidade Federal Fluminense. And you can maybe ask, what is Fluminense? Rosa once asked me, what is Fluminense? Fluminense is the gentilic for those who are born in the state of Rio. And those who are born in the city of Rio are cariocas. So our university, before I speak about university, just to have an idea, Brazil is the size of continental United States and has a population of more than 200 million inhabitants. Rio de Janeiro state is more or less the size of inland Maryland. Our population, 16 millions. And the capital in Rio de Janeiro city is 6.7 millions. And Niterói, 520,000, so it's much smaller. And here you can see, this is the Bay of Rio, the Guanabara Bay. On the left is the Rio de Janeiro city, the famous Rio de Janeiro. And you can see the bridge that takes you to Niterói. This is the bridge. So I live, in fact, in Rio, but I teach at Niterói. That means I have to cross this bridge when I go to the university. And here is a view of Niterói in the foreground and Rio de Janeiro in the background. So you can see you have a very nice view from Niterói to Rio de Janeiro. This area is Niterói. And here is the famous Sugarloaf. And behind the Sugarloaf you have the famous beach of Copacabana. I hope you visit it someday. I think Rosa has been there.
It's stunning.
Yes, and I live in Copacabana.
I imagine.
Well, this is our law school. You can see it's an old building. Obviously, this is a stage photograph. One of our students is reading the Constitution. Nobody does that, standing, studying the Constitution, because it's very dangerous. There is a busy street. You will risk being hit by a car if you do that. So they just make like a publicity. And these are the initials of our university in his hoodie. It's interesting, Professor Celorio, that in Brazil, the law schools were the first ones in the universities. So they are old buildings, sometimes not in good shape like ours. They need some renovation. But we have in Universidade Federal Fluminense, we have a huge campus because we have 10,000 students every year. And people try to convince us from the law school, go to the campus in a more modern building, but you know, people from law are very traditional and they prefer to stay in a decay building and to move for a modern one. As you say in France, décadence avec élégance. Elegant, although decay. So our law school has more than 100 years. It was consolidated inside the university only in the 60s. As I said, we have around 10,000 students, many different schools and institutes, and we are around 4,000 professors. So it's a huge university, as you can see. And our law school is ranked amongst the top 12 best public law schools in Brazil. In Brazil, the best law schools are the public ones. And there are some good private law schools too, but the public are considered most prestigious. Well, let's talk a little bit about Brazilian constitutional history, very briefly, to understand the context of my research. These are two official flags, or former official flags of Brazil. This, at your left, was our first constitution when Brazil became independent. You can see there is a monarchical flag because you have a crown and you have the symbols of Portuguese that colonized Brazil. These colors represent the Bragança family who belong to the Bourbon royal family, the yellow and green. And this fact explains why Brazil was not a republic in the 19th century, or great part of 19th century. The Brazilian history in the 19th century is very different from the Hispanic countries. Because, you know, when Hispanic countries like Mexico, Argentina, and Colombia became independent, they adopted the republican form of government. But Brazil, no, was a monarchy, and this is not difficult to understand. When Napoleon invaded the Iberic Peninsula, he arrested the King of Spain and took the King of Spain jail to Portugal. The King of Portugal was fearing the same would happen with him, so he just fled to Rio de Janeiro and declared that Rio de Janeiro would be the capital of the Portuguese Empire. So what happens is that the Rio de Janeiro became the capital of the empire, and Portugal became the colony. Portuguese were not very happy with this situation, but the king remained in Brazil for years. And when Napoleon was defeated in 1815, Portuguese people say, please come back. But he was liking the Rio de Janeiro beaches, and he said, no, I'll stay in Brazil for some more years. I'm not sure what's going on after Napoleon, because once he went back and tried to be in power. The fact is that the king remained in Brazil until 1821. And finally, he decided to go back because Portuguese were on the verge of doing a revolution. The king abandoned Portugal, and obviously the Brazilians were very unhappy now that the king was going back to Portugal, because he was bringing his treasury, and that would be very bad for the commerce and for the economy. So Brazilians decided to declare their independence too, but the king left his son, Pedro I, and said, okay, you'll be independent, but the king will be Pedro I. So it was a very bizarre situation, because we have an independent country, but with the same royal family in Portugal and Brazil. And this regime lasted for 64 years. We were a monarchy. And then, at a certain point, we had a second king, a second monarch, Pedro II, who was a very nice man, but he was getting old, and he had a lot of political problems due to the abolition of slavery, to the war with Paraguay, and the elites decided to oust him, and to declare a republic. And when Brazil becomes a republic, the leaders say, let's do the American way. Let's try to adopt the same institutions of the United States, like presidential system, bicameral Congress, constitutional court, and so on. And they were so enthusiastic that they decided to adopt this flag, that it looks like some flag you know. But this flag only lasted 4 days, because someone had the good sense to say, come on, this is ridiculous, this is too much, we can be inspired by some constitutional institutions, but no, let's do a better flag, and this is our flag, that I think it's very pretty. And if you think, it's like a mix of the imperial flag and that one that seemed like the United States, because the Brazilian flag, these stars represent the states, like the stars represent the states here in the United States. Well, why am I telling you this? Because when we become a republic and we adopt the new constitution in 1891, we will, you can see, adopt basically the same framework of the United States, with some differences, obviously, but it's the same framework. That's what is important for us to study American constitutional law. Because, you know, this guy was like the father of the Constitution, Rui Barbosa, a very important jurist, and he had a great admiration for the United States, for the Supreme Court. So we start to have a lot of influence from the American constitutional law in Brazil. Well, but let's go to my research. This is, for me, the greatest president of the United States ever, in my opinion, obviously, Franklin Delano Roosevelt. And he visited Brazil in 1936 when he met the president of Brazil, then Getúlio Vargas. And it's interesting that he noticed that Brazil is always trying to learn with the United States, but he says, pay attention. You can learn from the good things we have done, but also from the errors we have committed in the past. I think this is a lesson for us who like to study comparative law. Because sometimes when we study comparative law, we maybe underestimate our legislation and overestimate the legislation or the law of the country you are studying. And the contrary may also happen. We may overestimate our law and underestimate. So I always tell to my students, like Marco, who is here from Brazil, that we have to be very balanced about studying comparative law. Try to be neutral, if this is possible. Well, but I didn't know that Franklin Roosevelt had traveled to Brazil in the 30s. I know he had met Getúlio Vargas in 43 because of the World War in Brazil too, but I found out this in this research, that he in fact had traveled to Brazil, and for me this speech he makes in Rio de Janeiro is very surprising, because he says that he would like to remember, he's making like a toast at the end of the meeting, and he says, it was two people who invented the New Deal, the President of Brazil and the President of the United States. I was very surprised that he was aware that Brazil was always dealing with social issues at the time, especially labor legislation, that, as you know, was one of the main points in the New Deal program. And this is Getúlio Vargas. He was one of the most important presidents of our history. And he stayed in power from 1930 to 45. That it's the same period, almost the same period of Roosevelt. Roosevelt takes office in 33, and he remains until 45 too. Vargas was the main leader of the 1930 revolution in Brazil. He was elected president according to the 1934 constitution, but in 37 he led a coup and stayed in power until 45 as a dictator. So he's a very controversial figure in Brazil. He was ousted by the armed forces after the end of the World War, the Second World War, but he came back. You know, this comeback tradition for presidents, it's not a present thing. He came back in triumph because he was elected. He was a very popular president because exactly he enacted social legislation in Brazil, although he was a dictator for some time. And he had problems in his last term too, and he ended up committing suicide inside the presidential palace. You see that Brazilian politics is very exciting. It was a tragedy. People were desperate when he did it, and he committed suicide because he was on the verge of being ousted again by the armed forces. So he said, "You will not take me out of power." And there was a huge manifestation against the armed forces when he died. Professor Bob Cottrell asked me, what's your opinion about Vargas? It's always a very difficult question. I know Marco hates him because he was a very bad dictator in these 7 years. But I'm looking what he has done, not his personality. And it's very difficult to assess because he modernized Brazil in some way. It was under his president that women could vote, that he stopped the fraud in the electoral system, that he made labor laws, social security. So I answered Professor Bob Cottrell saying he was a chameleon. He knew where the wind was blowing, the way the the wind was blowing. He was a very talented politician. Well, why I'm doing this research? First, as I told you, I'm very interested about the influence of American constitutional law in Brazil. I teach a class about comparative American and Brazil constitutional law. I'm very interested too in FDR's New Deal. I work as an attorney in labor law, so I'm very interested in this issue. And also, Professor Celorio, studying here for this research, I noticed that there are tens of thousands of books about New Deal, about Roosevelt administration, but very few material about the impact of New Deal abroad. Maybe Americans like to look inside and don't have this look for the effects of internal politics abroad. And I think my research may be a contribution for this area too. I'm always interested in contradictions in lawmaking during the Vargas era because, as I said, he was a very controversial figure. He was a dictator, he was elected, he made some modern legislation. For instance, the penal code that we have still in force is from Vargas era, and the labor legislation basically is also from Vargas era. And I wish to make a contribution to contemporary debate about organized labor in Brazil. Brazil nowadays is a very polarized society, very partisanship like the United States. And you know that in United States and also in Brazil, the role of unions, of labor, is very contested, is very a hot issue. And a lot of people say we have to change this Brazilian legislation about unions because it was done under Vargas, who then was a dictator, and he was inspired by some fascist ideas of Mussolini, and maybe we should change this. But in general, who argues this is the conservative political forces who want to weaken the unions. So I'm trying to show in my research that yes, there are some authoritarian aspects of this legislation, but also some democratic aspects of this legislation that came from the New Deal. And we will see that this idea or this accusation against our labor legislation is based on the idea that it would be inspired by Italian corporatist ideology. So I think I decided to study what is corporatism, because although many people associate corporatism with Italian fascist or with Mussolini, corporatism was present too in the United States and in other democratic countries. So I'm trying to say or to show in this public debate, okay, we have some elements that come from the ideology that Mussolini adopted, but it's not so simple. It's more complex than this. And I reading a lot of articles and books about this theme here. It's very interesting because in the 30s, the people who were legal aides of Roosevelt were also accused of bringing some ideas from Italian fascists. So I want to know, how did corporatist ideology influence the New Deal too? And how New Deal's corporate legislation, especially the Wagner Act, I will talk about it, and the National Labor Relations Act, it's the same name, influenced Brazil legislation under Vargas regime. What is the effect, finally, of importing foreign legal ideas from a democratic country, United States, to an authoritarian or to an autocrat regime? So my first question is, what is corporatism? Corporatism is an ideology developed in the 19th century. It's a conservative ideology. And as every ideology of the 19th century, like socialism, liberalism, it has a lot of variants and versions and byproducts. So if we go to the French Revolution, Aisha, who knows this subject better than me, we know certainly the philosopher Saint-Simon, who at that time was defending some kind of corporatism for the representation in parliament. Or we have too, in the second half of the 18th century, Ferdinand Lassalle in Germany, who is one of the founders of the Social Democratic Party in Germany, that had an idea of cooperation between classes with government to achieve material progress. We have also the liberal corporatism. Stuart Mill, for instance, has this idea of bargaining interest not only in the personal level, but for groups. And this was very popular here in the United States, liberal corporatism. And especially important for Brazil, that is a very Catholic country, is the corporatism that was developed by the church, especially in the encyclicals Rerum Novarum and Quadragésimo Anno. You know that the church was very worried about social warfare in the 19th century, about the progress of communism, about the socialist ideas, and also about the condition of workers. So if you read these important encyclicals, you will see that the church suggests that to reach industrial peace, there must be a possibility of bottom-up organization of classes. And obviously, we have also the fascist corporatism. Why these ideologies developed, these versions of corporatism developed in the 19th century? Because of industrial revolution, of class conflict. And obviously, it was very important for conservatives to have some response to the progress of the socialist movement, once that the liberals were not giving good answers. And we have also American corporatism, that is the idea of regulating unions and collective bargaining inside the administrative state. Well, I think everyone has seen this photo. It's very emblematic. I thought this was a fake photo, like there were some platform under them, but no, it's not a fake photo. It's true. It was a staged photo, but there was nothing under them. This is the Rockefeller Center when they were building, and this photo is very emblematic because it's 32. It's the year of the election of FDR, and we were in the Big Depression. So FDR is elected, and he will be the president who will deal with labor conflicts in the United States. And I asked myself, why so late? Because at that time, the European countries had already legislation about labor, organized labor. And the United States had some very sparse legislation. But in my research, I tried to understand why only in the 30s that there is federal legislation on labor in the United States. Why so late? Because in Brazil too, in the beginning of the 30s, we didn't have labor legislation. So you see that it's very interesting to make this parallel between Brazil and the United States in this moment. Well, one of the reasons that the United States didn't have a good labor and employment legislation was that at the first decades of the 20th century, there was economic liberal thought that was prevailing in the United States, especially in the Supreme Court. It was a very activist and liberal not in the common sense, but in economic sense. So the Lochner era was known for this ruling of the Supreme Court that strikes a New York state law limiting the hours of workers in bakeries in New York. They said it is unconstitutional based on the idea of freedom of contract, due process of law of the 14th Amendment, but they defend a classic economic liberalism or laissez-faire. So, although the federal government tries to implement some employment laws, we know that the Supreme Court will strike all of them like this one, the famous case Adair v. United States, when the federal government tried to ban the yellow dog contracts. That means employers made a contract saying, if you are hired, you can't belong to a union. And if you join a union, you'll be fired. And the Supreme Court says, no, this is freedom of contract. You can't ban this practice. And in this case, Hammer v. Dagenhart, child labor, there were laws against child labor, and the Supreme Court says it's unconstitutional. Or the Adkins case, where the Supreme Court says the creation of minimum wages is unconstitutional because of freedom of contract. So we have a form too of corporatism, liberal corporatism ideology. That was the Fordism, Taylorism, the idea that organization of labor at plant level aiming to improve productivity, wages, and the quality of employees' life could be achieved by this doctrine of collaboration. But we know the reality that there was a lack of balance between employers and employees at workplace, as this famous Chaplin movie shows. And another fact, very interesting to understand why we take so long to have this labor legislation in the United States, is the immigration. These new immigrants that arrive in tens of thousands here in the United States, they bring with them foreign ideologies, anarchists, socialists, and this new workforce knew the power of organized labor in Europe and pressured for changes. So there was like a xenophobic fear of these foreign doctrines. And also it's important to remember the progressive movement here in the United States, but had like a moral vision of the issue. So they were against the evils of industrial capitalism, and they advocated for the necessity of government regulation, but some of its members feared organized labor. I think the progressive movement is a very interesting thing to study here. They were a little conservative, but they achieved a lot of things that improved the consequences of industrialization. And we have violence in the United States. There are a lot of violence, like this bombing of the Los Angeles Times building, a union protesting against the newspaper that was always anti-labor, just exploded the building of the Los Angeles Times. And after that, the government starts to be very worried about labor in the United States. Well, we have the Great Depression, the election of FDR, of Keynesian economy, and the rise of the administrative state. This you know. So in June 1933, in the National Industrial Recovery Act, Roosevelt will, for the first time, try to regulate labor in his plan of New Deal. But as you know, the Supreme Court will strike, because it was that old Supreme Court, very conservative, that says this act is unconstitutional. The history you know better than me. The Supreme Court confronts Roosevelt, and he makes the court packing plan to see if the Supreme Court steps back. But the Supreme Court will take some time to change its opinion. And finally, in 1937, they will say that the new labor legislation, the National Labor Relations Board, is constitutional. Well, these are two very important figures in this moment in the United States. The first one is the Senator Richard Wagner. That's why the act is called the Wagner Act, the Labor Relations Act. And this is a very fascinating woman, the Secretary of Labor, Frances Perkins. She was the first woman to be in a presidential cabinet in the history of the United States. And she stayed with FDR from the first term to the last day in power. And she was a very fierce advocate for labor organization. If you go to Constitutional Avenue here, there is the Department of Labor, and the building is called Francis Perkins Building. And these people, they made part of the so-called brain trust, FDR's brain trust. FDR was a very intellectual president, and he called a lot of people from academia to help him. And many of these members were also accused of having some sympathy for the fascist regime in Italy, especially this corporate ideology. Well, basically, the National Labor Relations Act has as main purpose to establish the legal right of most workers to organize or join labor and to bargain collectively with their employers. It was sponsored, as I said, by Senator Robert Wagner, that was in the inner circle of FDR, and has, for me, a characteristic of a corporate institution, because it's like a three-part member, or after five parts that represent workers and employers. Well, this is what the main aspects of the National Labor Relations Act are: the right to organize or join unions, National Labor Relations Board, that has some power to hear and decide procedural case in an administrative jurisdiction, and also the promotion of collective bargaining. Employers are compelled to bargain with representatives of the employees, and unfair labor practice are banned, among other things. Well, so this is the background of the FDR's labor legislation, and let's see now how this impacts Brazil. As I told you, Brazil had no federal rules on labor and employment before the 30s. The revolution of 1930 aimed at conservative modernization of the country. Its leaders rejected liberal economy. You know, this was very common in the 30s. There was an anti-liberal sentiment that made possible some authoritarian responses. But they also rejected, obviously, socialist doctrine. So corporatist in Brazil, or corporatism, was a doctrine that fitted that purpose. Brazilian corporativism has its roots in the Catholic corporatism and in the sociological positivism corporatism from Augusto Comte. That is in our flag, order and progress. These ideas were very popular at the end of the 19th century. The first minister of labor of Vargas' provisory government, Lindolfo Collor, issued a decree in 1931 that only unions licensed by the federal government have the right to collective bargaining. This was, in fact, an influence of the Italian Carta del Lavoro issued by Mussolini, the idea that the state would control the unions. Well, and this book is very, very interesting. I would say that reading this book, I had the idea of the research. This is Oliveira Viana. He's a legal professor in law, and also a sociologist. He was the main legal aid to President Vargas. He was the brain trust of President Vargas. And he knew very well the United States. Knew for reading. He had never been here. But this book was published in 1938. The National Labor Relations Board was enacted in 1935. So he wrote the book in 1937. So 2 years after the United States had its main labor piece of legislation, he was writing about it and saying, let's do this in Brazil. Workers have to have some agency where they can complain about their rights. But the problem is that, you see, he publishes this book in 1938, he writes in 1937, exactly when Vargas was becoming a dictator. So this is a very contradiction, because he's trying to say, let's do the same of the United States in an authoritarian state. But anyway, they will do it. So we can compare the National Labor Relations Act or the National Labor Relations legislation, with the Consolidação das Leis do Trabalho, that is the main code for Brazilian labor. And I'm not talking here about employment law, like hours and wages, but about organized labor. And you can see in a comparison that there are a lot of things that are similar because, as I told you, he was thinking about the American regulation. So, in the National Labor Relations Act, you have this legal rights to organize, use, or join unions. And in Brazil, in the labor code, you have this legal right, but on license of the government. Why? Because the government would not accept communist unions. You have the National Labor Relations Board, as we saw, that has this power to hear and decide procedural case. In Brazil, you have Justiça do Trabalho, who at the beginning was administrative jurisdiction, but later on it will be integrated to the judiciary. There can be only one exclusive bargaining representative for a unit of employees, that is only one union for a group of workers. It's the same in Brazil. The promotion of the practice and procedure of collective bargaining is as short as it is in Brazil. Employers are compelled to bargain with the representation of its employees, the same in Brazil. Employees can discuss wages in a collective bargain, the same in Brazil. Unfair labor practices are banned here in the United States, like the employer cannot fire someone because he's being an activist in the union. In Brazil, not so much. It only bans employers' lockdown. So you see that it's more conservative, gives more power to the employer. And in the American model, you have the system for collecting agency fees to the unions. In Brazil, we also have this system, but with the government participation because the government collects these fees like taxes and gives them to the unions. Well, I'm coming to the end. So, Brazilian labor legislation adopted many ideas and experiences of the New Deal when it still was controversial in the United States. You remember the Supreme Court was debating in 1937 if the National Labor Relations Act was constitutional or not. And Brazil was already looking at it. Nevertheless, the Brazilian Vargas regime during 1937-45 kept control of unions through autocratic concepts of corporatism, while allowing adjudications of collective bargaining based on the American model. The National Labor Relations Board was an inspiration for the creation of administrative Justiça do Trabalho that would be, as I told you, integrated to the federal judiciary after 46. So, some aspects of the Brazilian legislation were, in fact, authoritarian, due to the Vargas regime embracing dictatorship. As I said, unions depended on government license to be created. Agency fees also were collected as tax by the federal government and reverted to unions. And we have the adjudication of collective bargaining by the administrative courts. The democratic Brazilian Constitution of 1988, that is our current constitution, eliminated the most authoritarian corporatist elements of organized labor created in the Vargas era. So that means what was democratic in this legislation was preserved. And this, I think, is my final slide. This is the second meeting between Getúlio Vargas and FDR. It's wrong, it's not 42, it's 43. Why President Roosevelt comes back to Brazil? You know that President Roosevelt had a disability and that he used a wheelchair, but he didn't like to be seen in a wheelchair because this would make people think he's a weak man, and politically, obviously there was a lot of prejudice at that time. They would think he was not capable of being president. And the photos never show Roosevelt in his wheelchair. He's always in a normal chair, or he's sitting in a car. If you go to the Roosevelt Monument, you'll see that he is, in fact, there is a statue where he is, in fact, in a wheelchair. But he was in Brazil because of the Second World War, the United States were doing operations in the north of Africa, and Brazil was very important to have a stop for the planes and for the ships. So he tried to convince Vargas to become an ally in the war, and many people were in doubt about the Vargas position because he had like some sympathy for Mussolini. But he finally, he knew where the wind blows. And he decided to join the Allies. Brazil sent troops to Europe and to Italy, precisely. And he gave the air space, how do you say, an airport to the United States operation in the city of Natal. And FDR agreed to build siderurgy in Brazil to help the industrialization of the country. So my conclusion is that exchanges between legal cultures are affected by political regimes and by national realities. Legislation from a democratic country introduced to an authoritarian state can survive and thrive after the collapse of the regime. So I think this is a reflection about the comparative law between different regimes. Thank you very much for being here again. And I am here if someone has some questions.
Obviously.
Alison, if you don't make me a question, I think this is very strange.
You know, of course. So I've been typing all my questions.
Oh.
I hope he doesn't think I'm like on WhatsApp or something. No, it's the questions. So Cássio was wondering, are unions still regulated by the government in Brazil? Like, to what extent are they still regulated? And what's the impact of unionization on labor law practices? Because I know in South Africa, the unions rule the roost. You know, the government is actually so afraid of unions, and they form coalitions for numbers and strength. And usually when there's collective bargaining, there is a little bit of a fight, and the employer always likes to bully a little bit, but in the end, they always give in. So the unions are really, you know, rule the employment world from a South African perspective. What is that, you know, what's that like in Brazil?
Okay.
Do people, and also, you know, a lot of the time it's very classist, so it depends. It's, in the past, it used to be working class people that would belong to unions, factory workers, you know, people at the lower income group. But now it's really increasing everybody, you know, across the board belongs to unions because workers' rights have really become a thing.
Mm-hmm.
What's the case in
Well,
Brazil?
the first question, nowadays the government does not control the unions. The only problem is that you can only have one union representing a group of workers. So what happens if two unions are trying to represent these workers? The government, he will not, the government, I mean the executive branch, he will not say it's this one or that one. He will just make a register to see which union was first created, let's see. But if there are some conflicts, the judiciary will decide who is the legitimate union that will represent workers. Here in the United States, the system is a little different because the union who wants to represent a group of workers, he has to convince them that it's a good thing that he represents. They will make an election, and the National Labor Relations Board will regulate how this election is going to be. So it's a little different, but you have this idea that there are some rules for deciding which is the legitimate union. Unions in Brazil are not so strong as they are in South Africa. There are some sectors where they are very strong, like teachers, unions, metal workers, civil construction. But I think in the last decade, they were weakened by reforms that made difficult to them to collect fees, like it's happening here in the United States, and the Supreme Court here has been dealing with this subject. We had in Brazil a labor reform in 2017, very recently, that made much more difficult for unions to collect fees. So I believe now we are in a moment where we need to rethink the model of labor organization in Brazil. That's why I'm doing the research too. And this is a hot topic in our election because the president-elect, Luiz Inácio Lula da Silva, was a unionist. He started his career as a unionist, and people from his party, the Workers' Party, are saying we have to make a reform of the reform to grant some money to the unions because unions have to spend money hiring lawyers and make ads, and it's very expensive to have collective bargaining. So we think that maybe in the near future, this debate will surge again in Brazil about which is the best way to grant unions some kind of financial support. Because a problem we have in Brazil is that a lot of workers benefit from the unions like free riders. They don't pay fees, but they get the wage rises. So this is not fair. And there is the same problem here in the United States, in some states that they call free-to-work states, that have state legislation allowing or banning compulsory fees to the workers who benefit from wage rises. So you see that it's a debate that is happening here in the United States, it's happening in Brazil, and that involves constitutional problems of free association. Compulsory fees violate free association or not. So it's a debate that is very important in Brazil, and I think also in the United States now. Rosa.
I actually had a question. If you could compare a little bit the approach that Bolsonaro had towards labor unions and the one that Lula
Yes.
will have.
Yes. Bolsonaro, our former president, he's still in charge, but thank God for just 2 months. He was totally anti-union. He had a speech against workers' rights, so he was very pro-business. And this was a very ideological election because you have Bolsonaro, who's a former military man, who has a very conservative mind, anti-union, anti-worker, and you have a politician who was a former unionist. So that's why labor relations are such a hot topic in Brazil, because in the ads in the electoral campaign, this was very evident. Bolsonaro says we have to let people have business and produce, and he never talked about workers' rights. And Lula is the contrary. Although he is very moderate, in my view, he's not a socialist or a populist, maybe a little bit, but he will try to bring some power to the unions. What will not be easy because the Congress who was elected in the same election is very right-wing Congress. So I don't know. Let's wait the next chapter. Please.
I was really surprised by this presentation because, at least in Colombia, we don't have this kind of American influence on labor law. We have mainly influence from the ILO conventions, especially the 85 and all the conventions, 154, and the conventions about collective bargaining and the freedom of association and this. Do you think like the influence in Brazil is more American than the influence from the ILO conventions?
You know, as I showed at the beginning, we also have a lot of influence from Europe, from countries like France, like Portugal, who had rules about organized labor that were enacted before the United States. So I would say that our labor legislation is a mix of American, European, and also with the International Labor Organization conventions. We signed these conventions too. But we have a labor code that was enacted in the 40s. So it's like a puzzle of sources for labor in Brazil.
Especially because what you mentioned, like 2 seconds ago, about the exclusive bargaining union, what just one union representing all the workers, that's one of the features of the collective bargaining cis-skin of the alloy.
Mm-hmm.
So it seems like they are
in
have
collision.
this- yeah.
Yeah, sure.
They have this part within this American
Yeah,
way.
yeah.
Interesting. Very interesting.
Thank you very much. Please.
Thank you for your talk. In this country, we have pensions, of course, with unionized employees, but there have been problems with pensions being rated. Is that and unions typically have limited power. For example, in this country, we have very strong teachers unions, but
Mm-hmm.
there are serious problems with them being able to get their benefits, their pensions. That's a very big concern. The trade-off is that they're not paid competitively because they'll get a retirement
Mm-hmm.
when they retire. Is that a concern in your country?
Yes, I think in the United States we have to consider too that after the Second World War there was the second Red Scare here in the United States,
Yeah.
and they passed a legislation that weakened the unions here too. The Taft-Hartley Act, if I'm not wrong, of '46, that made the life of union and unionists much more difficult. So we have also the same problem in Brazil. We have a social security, so the pensions is not a problem for unions because there is a wide system of pensions in the social security laws. But yes, the Brazilian unions are being weakened, and the power of collective bargaining in Brazil is very reduced if we compare like 20 years ago.
Okay. All right. And do Brazilians have more respect for social programs than they do here? For example, when we have the election cycle, we have some of the more extreme right-wing candidates. They'll talk about defunding the entitlements because they think they're not necessary or they're not competitive or they're anti-capitalist. But it seems like that's not really an issue in Brazil.
Yes, I would say that our constitution is a social democratic constitution.
Okay.
A lot of people, liberal and conservative, criticize our social security, our system of public education, of public health, as a constitutional problem. They say we should maybe change and create a new constitution, a more liberal one, but I don't think it's the case. The problem is that we have also problems with budget, because everything costs money: social security, public health, and public education. But I think it's not probable that we will change this model soon, especially regarding the results of the election now, because there are many people in Brazil who don't like Lula or the Workers' Party, but they were more worried in keeping the Constitution and the social benefits the Constitution provides.
Okay. But they do grapple over it. For example, in the UK, nobody touches the National Health Service.
Yeah.
It's never debated
Yeah.
in the political sphere. It's just here to stay. But it sounds like it's a similar problem with the Brazilianos have the same problems with the Americans. Somebody will say, well, just defund it. We don't
Yeah.
need it. So okay.
Exactly. The Brazilian public health system was inspired in the British public health system, the NHS. Yeah. Alice.
As from a judicial review perspective, if an employer and a union can't agree on some issue, where do they go? Is there some type of labor court?
Yes, this is a difference that was very corporatist. They can go to a labor court, but after a reform we had in Brazil in 1998, the employer has to agree with the court that the court will play a role like an arbiter for the dispute.
And if they don't?
Workers can't strike. There is no compulsory adjudication anymore in Brazil. Please.
Maybe you already answered that question. Where do your union fund come from?
Sorry?
Your union fund, the fund, where
Okay.
do they come from?
Okay. The associates of the union, you can be associated with the union. The union represents all workers, okay? But you can also say, I want some benefits that only the associates to the union will give you. like you can have a medical plan, or you can have some kind of benefit that the union will give to you. So they have this money from the associates who contribute, but very few workers, in fact, do it, because if my main benefit is wage rises. So I don't care if I am affiliated or not, I will have the wage rises. So there are many unions in Brazil who are bankrupted now. So they are firing, including their lawyers, because they say we can't pay your wages anymore, we don't have funds.
In your research, did you make a suggestion of how to get more money, other funding?
Yes,
Did you explore that?
there are some proposals that in the collective bargain you would stipulate, not in the law, but in the collective bargain, you would stipulate that everyone who earns the benefits of the bargaining will have to contribute.
Yeah, because for example, in France, where I come from,
Mhm.
Every worker has to contribute to the union.
It's
So
a compulsory contribution.
Exactly.
Okay.
So you have the same system in Brazil?
No, not anymore after this reform of 2017. Yeah, sure.
Yes, and you can continue the discussion if you want after we end, but thank you so much, Cássio. It's really an honor to have you as one
Thank
of
you.
our visiting
Thank you very
scholars.
much.
And thank you so much for sharing this wonderful research with
Thank
us
you.
today. Thank you. And thank you